Good morning. Today is April 25th, 2017. We are on the second floor Judges Court Conference Room in the United States Courthouse on 101 West Lombard Street in Baltimore, Maryland. We are here to conduct the oral history of Judge Benson Everett Legg. My name is Evan Shea, and with me conducting the interview is P.J. Martinez. We both clerked for Judge Legg in 2007 and 2008, and now we are both Assistant United States Attorneys here in the District of Maryland. Good morning, Judge Legg.
Good morning.
I want to start at the beginning in your early life. You're a native Baltimorean. Can you tell us your fondest memories of growing up in Baltimore?
Well, I'm a native Baltimorean, as Evan and I were talking about this morning. We have exactly the same education. We both went to the Calvert Elementary School and then the Gilman School and then Princeton University and the University of Virginia Law School. Unfortunately for PJ, he didn't have the opportunity to go to any of these schools, but he was a fine clerk nonetheless.
And unlike me, PJ got his clerkship based on merit, whereas my academic credentials were what had to carry me.
That's true, and also I was a good friend of your father's. At Venable, he and I overlapped, and he was just a sensational lawyer, and now he's running for the governorship of Maryland. But you got your clerkship based upon merit, but the other factors sealed the deal.
Well, thank you. You talked about your education. When during your education did you decide that you wanted to become a lawyer?
I had a learning disability with respect to all things having to do with mathematics. So when I was taking the SATs back then, I had the most that you could get, the highest score was an 800, so I had a 728 in my verbal SAT and a 420 on my math SAT, so I had a 300 point differential. Which confirmed what my teachers knew, and that is that I had no aptitude whatsoever for mathematics. So that left out a good number of vocations, accounting, investment banking, but law was the left because law requires, unless you're going to be a tax lawyer, reading and writing and memorization and verbal skills. So I knew I wanted to be a lawyer, and that decision was confirmed by my father's best friend, Arthur Machen. Now, my father died when I was a boy in 1953 in a hunting accident, and his best friend was Arthur W. Machen, who had been his roommate at Princeton for 4 years, and then the two of them were in Boston after the war. There was a GI program, or that the Harvard Business School, where my father got his business degree, and the Harvard Law School had programs for returning military personnel after World War II where they could get their degrees in a hurry-up basis, which both of them did. So I remember sitting in the living room in our house talking to Arthur, who was then one of the best, just a very fine attorney at Venable, Bacher and Howard, and asking Arthur about the legal career and what was good and bad about it, and whether he thought that I would be a quote-unquote good fit for it. So Arthur's example made me desire to have a career in the law.
And you went to law school, and the rest was history. I want to dive straight in after law school in your early legal career and start kind of at the beginning of your legal career. You clerked in this court for Judge Frank Kaufman, and I was hoping you could share a few anecdotes about your clerkship with Judge Kaufman.
Yes, it was sort of an interesting process that led me to Judge Kaufman, who when I became his colleague, I later called Frank, although it was very difficult for me the first time to, as Herb might appreciate, to say, well, Frank. And second, a difficult breaking of the ice was to call Zandy Harvey Zandy instead of Judge Harvey. But in my last year in law school, I had 3 clerkship offers, one from Harrison Winter on the Fourth Circuit, and the second from Judge Harvey, and the third from Frank. And I decided that I would rather clerk on the district court. If I had to do it over again, I would have clerked on the district court and then the Fourth Circuit. But back then, people normally clerked just for 1 year. And I thought that it would be more interesting to clerk on the district court than the circuit court. And I had 2 friends. I did a summer associateship at Venable, and after my first year at Virginia Law School in 1971, and I became good friends with Jim Wright and Harvey Clapp, both of whom had clerked for Judge Kaufman. I also had a good friend named Jim Quarles, who went on to clerk for Judge Kaufman. And they highly recommended that I clerk for Judge Kaufman, and I thought that I would do that because district court, I get to see trials. Circuit court would just be reading and writing, which I was sort of sick of after law school. And I thought it would be better to clerk for Frank because Judge Harvey was a family friend. And I thought it would be better to have a clerkship with somebody with whom I had no family connection. That year was very memorable. My co-clerk was Dan Goldstein, and we've been friends ever since. And I just thought it was just a wonderful world. All these lawyers and cases appeared before us, and they were so interesting. Betty Wiegand was Frank's judicial secretary. Rose Elgin, that you might remember, was the court reporter, and Wes Booz, who had one of the world's all-time most memorable hairpieces, was the deputy courtroom clerk. I remember one hearing, as Herb will attest, Frank could be hard on attorneys. And Frank was giving one of the attorneys who was working for the government, I think he was working for the IRS, a very hard time. So I was sitting there, and Frank declared a recess, went off the bench, and the attorney went like that, sort of glad to see you go. So I thought this was rather humorous, so I went back to join Frank in the roving room, and I said, it's sort of interesting when, you're giving that lawyer a hard time, and when you went off the bench, you sort of went like that. And Judge Kaufman did not think that was amusing. So when we came back to resume the hearing, Judge Kaufman made me, at the bench, describe what had happened, just to my utter mortification. So I described what happened, and it was placed on the record, and then Frank upbraided the attorney, who then had to apologize. Well, it turned out that one of my first law clerks was that attorney's daughter. Mm-hmm. So I got to apologize to him in person for getting him in hot water.
And good, and karma was restored in the District Court of Maryland. I want to move from your clerkship to your early legal career at Venable. Can you tell us just briefly your experience as a young litigator in Baltimore?
I thought that, looking back to my clerkship, I thought that the district court was a wonderful world for the reasons that I've articulated. The idea of going into court for criminal trials, hearings, sentencings, the drama of seeing the jury return a verdict in a criminal case. Just a extremely interesting and varied world. So that, when I went to Venable and, let's say, graduated from law school in '73, clerkship with Frank was from '73 to '74. Then I started at Venable in '75. So I gravitated toward the litigation department and worked for many years with John Lewin very, very closely. in the early part, I got a call from Jervy Finney, who was then the U.S. Attorney. And Civiletti was then at the Justice Department. He was the Deputy Attorney General to Judge
Griffin Bell, was that
Griffin
right?
Bell, yes. And Jervy asked me to come on over, said, well, I'd like to hire you as an AUSA. I think then there was a hiring freeze, and part of Jervy's thinking was that if I had an opportunity from Venable to go to the U.S. Attorney's office, that Ben Civiletti would then lift the hiring freeze to allow me to do that, and Jervy would have an extra person on his complement. So I went to see Bill McCarthy, and who was then a good friend and one of the senior people at Venable, and he said, don't go to the U.S. Attorney's office because you'll just learn all this criminal law. Stay here at Venable and we'll give you all the trial experience that you need. And I've always been regretted that I did not pursue that avenue and go into the U.S. Attorney's office. In a sense, I made up for it when I became a judge, but I thought being an AUSA would have, as the three of you, Herb was for a long time and the two of you are now, is just a wonderful job, and they give you identification. You know, you can pull out, you know, federal prosecutor.
It's a great perk. When did you decide that you would seek a position on the district court here as a judge?
Well, I very much enjoyed working in private practice at Venable. I remember one of the things I liked so much was, you know, when you had a legal problem or issue about a case, I'd mosey on down the hallway, you know, knock on a door like your father's door, and you have 15 minutes to talk to me about the case. Loved talking about cases, and I always felt sorry for my clients because they seemed as if they had such, you know, boring jobs because they did the same thing day in and day out, whereas we got to do things that were different all the time. So I had a hankering to return to the district court. I also had a penchant for interest in politics, particularly I'm a Republican, and particularly Republican politics. Back in those days, which would have been the late 1980s, we had a healthy contingent of Republicans in the at the federal level. Several Republican congressmen, women like Marjorie Holt and Helen Bentley, and then Mac Mathias was a Republican senator, although Mac was pretty much in the mold of Jacob Javits and you know, Scoop Jackson. You know, he could have either been a Republican or a, you know, conservative Democrat. So I wanted to, attracted to politics, I wanted to get involved in, and also I had in the back of my mind that I'd like to either be, you know, maybe U.S. Attorney or to go on the bench. So a good friend of mine, Aurelia Bolton, who was very active with Helen Bentley, said, well, you ought to, if you're interested in politics, I'll put you in touch with Helen Bentley. So Helen was then the senior Republican in the Maryland congressional delegation. So I became very active with Helen and her, I had a good friend in her office named Carol Hirschberg, who was very helpful to me. So I was the head of Helen's Young Leaders group. I was sort of the mentor to the young leaders. And I also became, she was an early supporter of George H.W. Bush, Bush 41. So I was the Maryland counsel for the Bush primary campaign, and then I was the Maryland counsel for the Bush Quayle campaign in Maryland, and I was in the very active in the Maryland and the lawyers for Bush Quayle. Went to the Republican convention in 1988, which I believe was in New Orleans, and then worked on the campaign, and lo and behold, George H.W. Bush won. I remember going to the parking lot where I used to park when I was working at Venable. And from the parking lot, I could see the courthouse. And I thought, I may be able to get over to that courthouse in one capacity or another, and it might happen. So I remember going to see Helen, and I think I've talked about it with Civiletti and some other people. And so the question was, would I like to be, should I shoot to be on the U.S. Attorney or on the district court? And I remember going to see Helen at her house because there was a vacancy for both positions. And I said, Helen, I think maybe I'd like to be U.S. Attorney. So Helen said, she had a very gruff voice, a wonderful woman, no nonsense. She said, Dick's going to be U.S. Attorney. And I said, all right, well, I guess I'm not going to be U.S. Attorney. And she was referring to Dick Bennett, who did become U.S. Attorney. I said, well, then, being on the district court would be a lifelong ambition. She said, you're too young to be a district judge, and you have too much to give to the party. And also she meant, to her, because I was raising money for her and helpful. But over a period of time, she found out that district judges were going on the bench. I was then in my early 40s, so that I wasn't really too young. I was on the younger side, but not too young. So they needed, she needed to recommend someone, so she recommended me. And back in those days, it was a lot easier to go through the process and get confirmed than it is today.
Can you tell us about the confirmation process and specifically the confirmation hearing?
Well, I remember going down to the Justice Department. I remember meeting John Roberts, who was very impressive, because I knew we were going to have constitutional questions. I hired Bruce Fine. Bruce is a constitutional scholar who had also clerked for Judge Kaufman. And I remember going down to Bruce's house, and we brushed up on the United States Constitution, because if you're a commercial litigator, you don't have many, which I was at Venable, you don't have many constitutional issues. So, Bruce, tell me about this First Amendment. What does it say and what is the jurisprudence? So that I was boned up on the issues when I went to my interviews and also in the confirmation process. The confirmation process was pretty easy. I remember going to my hearing. I had with me my mother, my wife, and my two sons, who were then little boys. And I remember one of the senators said, well, you're a partner at a big law firm. You're probably making a lot of money. You're going to have to take a pay cut to go on the bench. How are you going to afford that? So I looked around, and there was my wife sitting in the back, my lovely wife, who was had a fantastic career in business and now sits on 5 boards. And I said, my wife is a substantial businesswoman, and she fully supports me in my desire to be on the district court. So I was confirmed, I think, unanimously, and then joined the bench in September of 1991. Of course, back then, the conventional thinking and my thinking was that I didn't have to be in a hurry because George H.W. Bush would have a second term, but that turned out to be not the case, so I squeaked in, just under the wire. So I'm glad I did.
Great. Well, with that, I want to turn things over to my colleague and friend, P.J. Martinez, to talk a little bit about your early days on the bench.
Judge Legg, good morning.
Good morning.
Let's start at the beginning of your judicial career. It's 1991. You're in your early 40s, one of the youngest, if not the youngest, members of the federal judiciary. Could you talk to us about the learning curve that you had as a federal district judge and what some of the challenging aspects of that learning curve were?
Well, when I was at Venable, we actually had a big library. In those days, law firms had libraries, physical libraries. And sort of one amusing anecdote, when I was at Venable, for a while I worked for Fred Motz, who then, this was after he'd been U.S. Attorney, but before he went on the bench. And I remember we were writing a brief, I think it was in the Court of Special Appeals. And I was there on the weekend, and we had a case that was all in our favor. So I had to shepherdize it, and back in those days, the only way you could shepherdize a case was to find the physical volumes and read them to see if the case had been criticized or overturned. And the most recent volume was onion skin, extremely thin. And I couldn't find it anywhere. It wasn't in the library. I went all around the offices looking at people's desks, couldn't find it. So I figured, what are the chances that this case, anything happened to this case over the last few months, negligible. So we submitted the brief, and I found out about a week later that case had been reversed. And I remember talking to my wife, and I said, I think, if I were Fred, I'd probably fire me because of, it makes us all look bad. And she said he wouldn't do that. He's fair, but you've got to promise you wouldn't do that again. So I did, and Fred was a wonderful boss at Venable. And when I went on the court, he was my mentor. So when I had a question about how to do things, I went to see Fred, and I would do what Fred did because it always made such sense. Over the course of my career, I had 3 major spinal operations, 2 in my lumbar spine and then the 3rd in my cervical spine. For the first 2, I was out for 7 or 8 weeks, and for the 3rd, I was out for about 5 weeks. And during that time, Fred took my docket and kept it going, in addition to all of his other work. And I've often joked that, the lawyers in my cases were probably sorry to see Fred leave and me return, but, what a wonderful lawyer, wonderful judge, wonderful role model. You couldn't pick somebody better to emulate. I also emulated, Zandy Harvey, who was just also a wonderful judge. They were my 2 role models. So I had good role models to pattern myself after. The biggest challenge was trying to learn criminal law. Which takes us back to Venable in the library. Every year, John Nixdorf, our librarian, would bring around the new Federal Rules of Criminal Procedure and the new Federal Rules of Civil Procedure. So I would take the civil rules, put them on my desk, take the criminal rules, put them in my little bookshelf. Then the next year he would pick up the criminal rules unopened and give me the new set of civil rules. So when I went over to the court, I thought, how am I going to learn this entirely new world? I'd heard the names of people like Archie Tuminelli, who were criminal defense lawyers, but I didn't know them. I just knew them by name. I hadn't read the criminal rules. And I felt daunted because I didn't know what happened behind the scenes. If you want to be a good civil litigator, you have to know what happens in the interaction between attorneys and client. Who has the upper hand in certain cases, certain matters? How does billing work? How does client retention work? What's the relationship between an attorney and opposing counsel? What are the pressures on an attorney to bill and collect and to retain clients? And if you know the backstory, what happens behind the scenes, you'll be a better judge in civil cases. But I knew absolutely nothing about the backstory in the criminal world. What I did is I talked to people as much as I talked to people about what happened. And also I couldn't wait for 2 years before taking my first criminal case. So I decided I'm just going to ask questions. So I remember my first suppression hearing. defense has moved to suppress something. Government's there. So I said, well, you, Mr. Defense Attorney, you've moved to suppress this evidence. And so even though you've moved to suppress, it's not your burden of proof, it's the government's burden to prove that the evidence was properly seized. Isn't that right? And everybody agreed that that was right, so now we're going to move on. So the government has the burden. How are you going to discharge this burden? Well, I'm going to call some cases, call some witnesses and question them, and so we're off to the races. It wasn't quite that simple, but it was a lot like that because I decided the best thing to do is to confess ignorance and ask. And then after doing it for a few years, you learn. And but I still felt somewhat hampered by not knowing all of the backstory. But over the course of years, I felt that I knew enough to be a good workman-like judge in criminal cases. The other thing I started to do was to compile my criminal case checklist, which I have in my hands. It's now 9 pages, and I believe that it's still in use in the U.S. Attorney's Office.
Yes, Judge, it's still, you're still noticed in the courthouse and in the U.S. Attorney's Office for having developed that checklist. It's still utilized by prosecutors, defense attorneys, and judges here.
Good. Make sure it always has my name on it.
We will. Well, could you tell us a little bit about how that checklist was developed?
Well, for about the first 3 years, it seemed to me that very prominent criminal defense lawyer, Billy Murphy, had been specially assigned to me because I had him in case after case. And he was almost invariably opposed by Dale Kelberman, who was a first-rate prosecutor, and Mr. Murphy, first-rate defense attorney. And the two of them would really go after it, as my mother would say, like Kilkenny cats. I remember one time Billy said, in sort of open court, I had to calm them down. If we were here in a fair fight, and you didn't have all the tools, I'd like to see what happened then. And I said, now, gentlemen, let's all, behave. But he was sort of referencing the fact that the government has a lot of the tools with which to work, and that the conviction rate is very high. But Billy worked extremely hard just to find attorney. I think one might say that when the case started, because he had a very busy practice, handled a lot of cases, that he might not be completely up to speed about the case, but after the first day, he was a master of the record, and he would use whatever lever came to hand to try to advance the interest of his client. So he would raise what might be called, roadblocks or obstacles to the government's case. And every time one of the obstacles was raised, I would analyze it, figure out how it should be handled in future cases, and then add that item to my checklist. So for example, paragraph 4, lowercase ii, the witnesses says, defense counsel may cross-examine a witness on his drug or alcohol abuse. The witness's drug and alcoholism treatment records are not discoverable because Billy had subpoenaed the drug and alcohol treatment records for a cooperating witness or two. And any trial subpoena requesting them will be quashed. United States versus Smith, because I didn't want some other defense attorney to get the same bright idea. Records of prison drug treatment programs are likewise not discoverable unless the government has information that the defendant has used drugs or alcohol while incarcerated. Then the next paragraph says, if the government has knowledge of a witness's past or present mental illness, it must disclose that fact to the defense if the illness is not of sufficient severity to have compromised the witness's ability to perceive or testify accurately. The government is not, however, under any obligation to ask its witnesses if they have ever been in therapy or to search for therapy records, because Billy had argued that a witness's mental health or drug treatment therapy records were Brady material or Jenks material. And so I laid out the ground rules. And as these similar roadblocks, issues came up, we, resolved them, and then I put them in the checklist.
And once you laid down these ground rules, Judge, and you started using the checklist, did you find that criminal cases before you went forward more efficiently?
They did, because the checklist became my Rule 16 conference, or pretrial conference. And there are issues that have to do with fault on both sides. I think Herb will appreciate this as a former AUSA. I actually had one case in which the AUSA told the jury in opening statement, "Ladies and gentlemen, Judge Legg has mentioned this beyond the reasonable doubt standard here in criminal cases. And it may sound like a heavy burden, but it's really not. The prisons are full of people that juries have convicted beyond a reasonable doubt." I sort of looked down, put my head in my hands. The defense attorney, rocketed skyward. And so I had to tell the AUSA that that was not an appropriate argument, and I reinforced it by calling up the U.S. attorney and saying that he might want to get the word out among his troops that, or her troops, that this might not, wasn't a good argument. And other questioning that I never liked was for a cooperating witness, which do you value more, your liberty or the truth? I just thought that was a rhetorical question, so I wanted to make sure that everybody knew what I thought was fair and what was foul. We talked about this morning, but in one instance, in a civil case, the plaintiff's attorney took it upon himself to introduce not only himself and his client, but the defense attorney and those at defense counsel, and I thought he was going to, we started to introduce the deputy courtroom clerk before I cut him off, and I thought I'd better stick that in the pretrial checklist as well, because I used to use the checklist in civil cases as well for some of the other trial craft issues.
Well, you mentioned trials. Before we move on to civil cases, I wanted to ask you about a couple of memorable criminal trials that you had during your career. The first is, as we've heard through courthouse lore, that you once had a bank robbery case involving a defendant who dressed as Santa Claus. Could you tell us about that one?
Well, I did, and it's, when you think about the criminal docket, every criminal case is a tragedy on many levels. It's a tragedy for the young man, because usually the defendants are young men who will have spent usually and will spend so much of their life in incarcerated. But putting that aside, nevertheless, there can be moments of levity and humor in virtually any case. So I had, and many of them involve bank robberies, because bank robberies are often not well thought out. One of my early ones, the bank robbers had robbed the bank and made their getaway on foot. It was snowing at the time, so what the police did is they followed the footprints, and then they saw the footprints go up a fire escape, and they went up the fire escape and they found the two defendants dividing the money in a room. But with the Santa Claus bank robber, I won't mention names, we'll call him Mr. C. Mr. C thought he should disguise himself, so he got a Santa Claus outfit complete with a beard. He went out he took a cab to a suburban bank that was located in a strip shopping center. He went into the bank and gave the teller a note. No die packs, give me all your money. So the teller gave him money with the bait money that had the die pack in it. He left the bank, and of course leaving the bank triggered the die pack to erupt with a billowing of purple smoke. He then ran down the parking lot, took a left-hand turn into an adjoining parking lot where there was a motel, and the witnesses to the bank robbery saw him run across the motel parking lot and into a motel room. So the police were summoned. They came and opened up the door, and they found the defendant wearing parts of his Santa Claus outfit with parts of he hadn't had an opportunity to get all of the beard unstuck to his face, and they found the rest of the Santa Claus outfit and the money up in the ceiling of the motel room. One might think that this case would plead guilty, but it didn't. It went to trial. And the defense did not have a lot to work with, but they did their best. But that was, it's a shame that there couldn't have been a way to persuade him to plead guilty, or at least to find that he was not mentally fit to stand trial, although he was evaluated and found to be competent. He just didn't want to plead guilty.
Well, Evan and I are still hoping for a case where the evidence is that strong. There's another bank robbery case that occurred more recently in your career that I believe you wanted to talk about as well. I won't mention the defendant's name, but there was a memorable, I believe this defendant represented himself, and there was a memorable cross-examination that I was hoping you could tell us about.
Yes, that was Mr. D, and this is another tragedy because Mr. D robbed a bank, and the two of the witnesses who testified against him were his wife and his cousin, and his cousin had been the other person in the bank with him. But he decided nevertheless to stand trial, and he was an engaging individual. He was polite, he had a sense of humor, he was bright, and he really gave me just the sense of just wasted opportunity and a tragedy of the Baltimore City school system. They had the group that they had decided to rob the bank on a certain day, but they changed on a Wednesday, but then they decided they were going to postpone that one day to a Thursday. And it turned out that they had 4 children, that the babysitter wasn't available on Thursday, so they took the children with them. The wife drove the getaway car, and they took the children with them. So the children were in the back seat. How was the crime discovered? The crime was discovered because after they had the robbery, they went out and purchased with cash 2 extremely flashy automobiles, which they then parked in front of their house. Their house was a house of somebody who had modest means, which attracted a lot of attention. In the suppression hearing, the defendant, Mr. D, the question was whether the authorities had, the authorities were talking about the DNA swabs that they took inside the bank. And one of the swabs was of a chandelier that was over the teller countertop because the defendant had jumped on top of the counter, and there was a question as to whether or not he'd hit his head on one of the chandeliers, knocking it askew. And there was some testimony about the knocking it askew, and Mr. D began to blurt out that, "That's not right, I he was about to say, "I never hit my head on the chandelier," when he stopped himself.
He objected to his own line of questioning?
He did. The other, I think the incident that you remarked about, his wife was on the stand, and this did have elements of tragedy. And Mr. D was asking his wife, "How many times did you cheat on me?" And Jim Warwick, who was the AUSA, objected. And during the trial, much to Jim's dismay, when Mr. D was trying to do something that was objectionable, I'd call everybody up to the bench and I'd tell Mr. D how he could do it. You can't ask this question, but if you want to get into that subject matter, you can ask him, the witness, X, Y, and Z. He'd look up and he'd thank me politely and he'd go back and do it, and Jim was not amused. So
Judge, did Mr. D get a copy of your criminal case checklist?
he did.
Okay.
So Jim got up and objected, and I said, this could go to bias, plus I wanted to hear the answer. So I said, I'm going to overrule the question, overrule the objection. So Mr. D repeated the question, and his wife said, "Twice." And he then said, "Try again." Mr. Warwick objected again. I overruled the objection, valid cross-examination. And the wife said, "3 times." And Mr. D said, "Correct."
Well, that's a memorable line of impeachment.
Can I say one other thing about that trial that sort of also made it a tragedy? They found in his apartment, in his wife's apartment, a videotape that he had made when he was casing out the bank. So he'd gone to the bank with his video camera, and you could see him panning, he was taking the pictures through the window, and you could see the inside of the bank, but you could hear he was narrating at the same time. Here you can see that the hours are 9 to 5, and it's clearly Mr. D's voice. And one time you could see very clearly for about 30 or 45 seconds his reflection in the glass, and it's clearly Mr. D. So the whole thing was a tragedy, but with some elements of levity.
Indeed. Well, I think that's a good time to transition back to your civil caseload, and Evan has some questions to ask you about some of the memorable civil cases you had during your career.
Thank you, PJ. Yes, Your Honor, we talked a bit about your criminal docket, and I want to run through a few of your memorable civil cases. The first one I want to start with is Merck Medco Managed Care versus Rite Aid et al. I want to just set the stage real quick on the players in that case.
Because I might not remember.
That's not why. But Merck Medco was what's called it was a division or a subsidiary of Merck, the pharmaceutical company that ran what's called a pharmaceutical benefits management business. And the state of Maryland had a large number of former employees who were receiving pensions and had the right to buy discounted pharmaceuticals under their pension plan. So what Maryland did was put out a bid for a contract to provide their pension people who receive pensions the discounted pharmaceuticals to which they were entitled. So the pharmaceutical benefits managers had to provide a network of pharmacies that were willing to provide these discounted pharmaceuticals. And Rite Aid, Giant, and some of the other major pharmacies were potential members of this. Epic Pharmacy were potential members of this pharmacy plan. So with that, what was the issue in the case, and what were the claims being made?
The case was a Sherman Act case, and Merck Medco was unable to put together a sufficient group of pharmacies to satisfy Maryland, so Merck Medco lost the contract. Merck Medco contended that the pharmacies talked to one another, conspired together, and reached an agreement in restraint of trade not to join the group. So that the conversation would go something like this: I'm Giant, you're Rite Aid. Look, if we both join this group, we're going to have to sell prescription drugs at a steep discount. We're not going to make any money. If I'm the only one outside the group, then you'll get market share. But if we both agree, and we agree with some of these others not to join, then Merck Medco won't be able to put together the group. We won't have to sell drugs at discount. And so it was a Sherman Act violation. And then there was a Lanham Act claim and a Lanham Act counterclaim, but it was false advertising claim, but it was primarily Sherman Act antitrust case. And I thought it was a sensational case because, one, complicated issues, or it was a, well, let me jump back for a second. It was, like many cases, one that taught me a lot about how the economy and society works. So I got to have a tutorial in managed care plans and pharmacies and how they price, and so it's a free education for me. Two, we had excellent lawyers. Lou Noonberg, who was representing one of the defendants. Jake Stein represented a defendant. Ward Coe represented Epic. Michael Brockmeyer, you had the lawyers for the plaintiffs were very good, so really adept, qualified lawyers. I felt the burden of reaching the right decision because I had I decided the case on a motion for summary judgment, meaning that it's I, as the judge, who's making the decision about the case rather than letting it go to the jury. So I felt the burden of reaching a right decision. For one reason, I realized from having been at Venable for so many years how important big case like that was to the individual lawyers involved. So I wanted to make sure that I got it right because it could impact their careers. So I had 4 hearings. We had a lot of briefing, many hearings, and I finally issued an opinion ruling that there was insufficient evidence of collusion to justify the case going to the jury, so I granted the motion for summary judgment. I had thought, in my early part of my career at Venable, there were antitrust cases. And I remember at Venable I was involved as a very junior level in a extremely large criminal antitrust case involving the independent gasoline marketing industry. And I thought that life in private practice and on the bench was going to be a series of big antitrust, big securities cases. But we found out that antitrust cases are few and far between. I think that's the case nationwide in terms of litigation. You still have business lawyers who are employed crafting business deals that can make sure they pass antitrust muster, but sort of antitrust as a litigation specialty is sort of gone by the wayside, leading to the demise of the Howry and Simon law firm.
Great. Well, I know for you in particular, given that complex civil litigation is your specialty, that it's much to your chagrin that those cases are few and far between. So, Judge, I want to move to another complex civil litigation case that you had before you, which I know is your area of expertise. This was the case, another Lanham Act case of Ameritox v. Millennium. And just to, again, set the stage, this case involved 2 urine drug testing companies. And the urine drug testing industry involved companies that would provide services to medical care providers called urine testing. And the urine testing would be used in conjunction with the prescription of opioids to monitor the patient's use of opioids to give the doctors and medical caregivers assurance that the patients were using their opioids appropriately, because misuse could lead to addiction and all sorts of other bad things, both overuse by the patient but also underuse that could indicate that they were selling their drugs to people who were not prescribed it. And again, these two players were competitors and provided the same urine drug testing services. So can you tell us what the dispute was between these two companies, Ameritox and Millennium?
Good. I'd be happy to. The hydrocodone, oxycodone industry presents any number of problems for society. There's an incentive for the manufacturers to manufacture and sell. There's an incentive for the doctor to prescribe, because if I prescribe, I'm a doctor and I prescribe hydrocodone or oxycodone, the patient has to come back to see me at intervals of 2 or 3 months. And the doctor, these visits tend to be short, and the doctor can bill the insurance company or Medicare or Medicaid for the visit. So it's a moneymaker for the doctor. The desire of people to get oxycodone and hydrocodone, and the desire of some doctors to prescribe them, has created this pill mill industry. There was, I think, a book or a movie, I think it was called American Pain, and it was about a pill mill in Florida, and entrepreneurs would bring in busloads of people from Arkansas and Georgia and the Panhandle down to, I think it was Miami. They would go to the pain clinic. A pain doctor would sort of give everybody the once over, you know, how's your pain, are you in pain? And then all of the people in the bus would get the prescriptions for oxycodone or hydrocodone, which they could either use or sell. So these two companies were competitors in the urinalysis industry. And the dispute between the two of them centered on the fact that urinalysis can tell you whether oxycodone or hydrocodone are in the bloodstream, or in the urinalysis, in the urine, but the urine test can't tell you the dosage that the individual took originally, or how far back in the past the drugs were taken. So the two companies asserted that the other claim and counterclaim were falsely advertising that their urinalysis service was able to detect recency and dosage, either falsely claiming or suggesting. So it was a Lanham Act case involving the advertisements of the plaintiff and the defendant. Millennium was the plaintiff, Ameritox was the defendant, but they had cross claims. Some cases, some large cases sort of move along with little friction in the system. And you know that you've got the large case, but the next thing you know, it's teed up for summary judgment and they haven't had any discovery disputes, and or that we're scheduling a pretrial conference for the trial. Other cases they're like the Battle of the Somme in the First World War. They just, every tiny litigation event is hotly contested, meaning that the judge time to supervise the case is magnified. Good lawyers on both sides, fine lawyers on both sides, but this was just a dogged fight that would have made Winston Churchill proud.
One aspect of the case that I wanted to ask you about that you took advantage of was the retention of an independent expert, not for either party in particular, but really to aid you, the court, in deciding some of the expert issues that were in play. Can you tell us about your decision to do that and how you came about that decision?
Well, under the Lanham Act gives a competitor the right to sue another competitor for a false advertisement. An advertisement can either be literally false or it can be misleading. If an advertisement is literally false, makes a literally false claim, then the falsity can be adjudicated. If a advertisement is literally true but misleading, there can be a Lanham Act violation, but the plaintiff must put on evidence, survey evidence, that establishes that a significant number of people were misled by the advertisement, even though the advertisement was literally true. A case was teed up for a jury trial because a number of the advertisements of Ameritox, the defendant, were allegedly literally true but misleading, which meant that Millennium had to have survey evidence. I think I've gotten that right. And the two sides hotly contested whether Millennium's survey was a validly conducted and appropriate survey. So this presented some angst to me because the Lanham Act, if you're a district judge, you are by definition a generalist because you have a criminal docket, you have a civil docket, you have a smorgasbord of types of cases. So here I have litigation in which the attorneys are specialists in the, know a lot more about the Lanham Act and surveys than I do. And plus there's sort of a thought in the back of your mind that if, really good lawyers at really good firms say that the survey is good, maybe it is good. So what I did is both sides had agreed and had cited to a survey specialist who had given guidance in a section of the Manual for Complex Litigation, which is published by the Federal Judicial Center. So I thought, well, here's what I'll do. I'm going to contact this specialist, who is a woman, I'm blocking on her name, and I'm going to retain her as an expert to help advise the court on a complex matter. I'm going to make the attorneys pay for the expert. And both of them had cited this woman as a leading expert, so who could object? So I did that, and I then had a conversation with her, and I told her that you're going to hear the issues, what do you need? We'll send you the surveys, need your opinion as to whether the survey of the plaintiff is valid or invalid. Then we're going to have a telephone conference call. You're going to tell me in real time what you think, and you're going to tell the lawyers as well, because they're going to be on the conference call. I think that's how it came about. And she poured cold water on the plaintiff's survey. And I remember during that conference call, one of the lawyers for the plaintiff started to try to cross-examine her, and I cut that off very quickly. And then a couple of days later, I made my own independent decision that the survey was flawed, could not be used. But in doing so, I took into consideration her views. So that was very helpful for me and made me feel much more comfortable that I'd made the right decision.
And the last point I wanted to cover on that case was how it ended, which I think was kind of unique and also indicative of the contentiousness of the litigation. So could you tell us a bit about, it was a settlement, but how the settlement came about and then the brief aftermath of the settlement?
Well, as I mentioned, I teed the case up as a jury trial. I granted summary judgment relatively shortly before trial. But I decided to have a jury anyway, and the jury would be an advisory jury, which I was permitted to do. So the trial is hard fought. And at the end of the trial, the jury was trying to decide whether a certain number of the defendants' advertisements were literally false. And the advisory jury decided that they were. I believe that's correct. And then I took a weekend and did my own analysis, and then I decided that I was going to make my own decision, but that I would take into consideration the advice of the jury, which I'm permitted to do. There were still some issues left to be litigated, and I decided that the case had gone on far enough. So I did two things. I told counsel when we convened for that day of trial to tee up the next section of litigation. I said, here's what we're going to do. First of all, I'm telling you now that I'm not going to grant attorney's fees to either side. Under the Lanham Act, I can grant attorney's fees, but I promise you neither side will see a penny of attorney's fees from the other. It's not going to happen. So don't continue to litigate because you think you're going to get your attorney's fees paid for by the other side. Second, this case has consumed an awful lot of judicial resources, and I think that you ought to give settlement a shot. So I've made an appointment with you, or for you, with Judge Stephanie Gallagher at 11 o'clock today, and please go up and see her and see if you can get the case settled, and if you can't, we'll have the next phase of the trial, but if you can, all to the good. So they had a settlement conference until midnight. I think it was midnight, Stephanie told me, and they got the case settled and resolved, and I thought, case is completely off my docket, but that was not the case.
So what happened after the settlement occurred? I take it you saw the litigants once again.
I was holding a rearrangement. I looked out in the gallery, and there were lawyers from the litigation in the gallery, and I thought this is not good news. And so I went back into chambers, and I found out from Rogue and Nunn that new lawsuits had been filed, new Lanham Act lawsuits had been filed, in which each side had contended that the other side had issued false and misleading press releases concerning the settlement. So
How did you resolve that?
Well, I was faced
the new lawsuit.
The new lawsuit. So I'm faced with a new set of litigation. So what I did is I held a hearing, and I told counsel that here's what I'm going to do. I'm going to write an opinion in which I will lay out, from an historical standpoint, the history of this litigation. And once I do, I am then going to dismiss the new cases with prejudice. And the rationale being that the only authoritative source for the history of the litigation is me. And so this case is over. And so I then took, it took a while because I sort of put it on the back burner, but I think I issued something like a 20-page opinion in which, I as neutrally and objectively put out what happened in the litigation, and I had it published by West, and litigation was over. And I don't think they took an appeal, but I think they started suing each other in other states.
Well, here's hoping they're not sitting outside the conference room waiting to pull you out of retirement for round three. The third civil case I wanted to cover is the case of Woolard v. Sheridan. And that involved Maryland's handgun permitting regulations and a challenge to that set of administrative guidelines. Can you tell us about what the claim was in that particular lawsuit?
The Woolard case followed from the Heller case. Heller was a very important Supreme Court case involving the right of the public to possess a firearm, specifically a handgun, for self-defense. The context of Heller is the Second Amendment's guarantee of the right to keep and bear arms in order to have a well-regulated militia. That's not exactly the formulation, but that's approximate. So the Heller court was called upon to decide whether the right to keep and bear arms is specific to having a militia, or whether it's specific to the right of individual citizens to keep and bear arms. And, back in the old days, those farmers and small tradesmen who had guns were the militia, so to speak. Heller said that the right is not confined to having a militia, but it's a right that is given to each citizen. Heller also decided that in Heller, the District of Columbia had a municipal ordinance which prohibited anyone in the District of Columbia from having a handgun, and I think include also a long gun, which meant that you couldn't have a firearm in your house for any reason. So the Supreme Court held that there's a right to have a firearm, including a handgun, which is the most typical type of weapon used in self-defense, and you're allowed to have it in your home. So Woolard was essentially the next step in the Second Amendment litigation canon, which is under what circumstances does a citizen have the right to take his gun from his house and carry it around on the street or in his car or her car.
And what did you find with respect to Maryland's permitting regulation of the individual's right to carry a gun outside of his home? What was the legal problem with it, and what did you find?
Well, Maryland had there are a number of different state regimens. I think it's accurate that if you live in Texas, you can get a permit and carry a concealed weapon. Maryland was a may carry state, which meant that people could carry a firearm, but in order to get a permit, the applicant would have to go before a board to show good and substantial cause why the applicant needed to carry around a firearm. And so, for example, a person who was if you were a judge, so to speak, and you had a criminal, a drug docket, you could get one. Or if you owned a jewelry store and you were carrying around jewels and large money, you could probably get one. But they were hard to get, and the question was whether they were too hard to get. Second Amendment was analyzed under intermediate scrutiny, and you looked that up, so tell us what intermediate scrutiny is.
The intermediate scrutiny is that there needs to be a substantial reason for the government to pass a law that infringes upon the rights involved, and that law needs to have a appropriate fit with the reason that is given. So you found that Maryland's Second Amendment, or the Maryland's handgun permitting system was a rationing system in effect, and that therefore the fit was not right with the justification the state had to abridge the Second Amendment right to carry guns. So
right.
Leave it to you to expound upon that.
Yes, and essentially, if you look at the intermediate scrutiny, there must be fit between the objectives to be served by the legislation and the aspects and components of the legislation, so it can't be overbroad. The type of component principles or public goods to be served would be, you don't want people, for example, who have mental health problems carrying around firearms. You don't want felons, convicted felons, to carry around firearms and the like. Maryland essentially conceded that its system was a rationing system designed to hold down the number of individuals who could legally carry firearms around. So they essentially conceded that that was the objective, and that they made it hard, and that so it made it very difficult for the state to prove that there was a fit. And what I concluded, and this is part my language, and it's also part Rogan Nunn's language.
And for everyone, Rogan Nunn was your law clerk.
Law clerk.
Right.
And at bottom, I wrote, "This case rests on a simple proposition. If the government wishes to burden a right guaranteed by the Constitution, it may do so provided that it can show a satisfactory justification and a sufficiently adapted method. The showing, however, is always the government's to make. A citizen may not be required to offer a, quote, good and substantial reason, close quote, why he should be permitted to exercise his rights. The right's existence is all the reason he needs." So that was my view, and issued the opinion, and then went on to the next case.
Right, and the coda to this is, I guess, a panel of the Fourth Circuit, shall we say, respectfully disagreed with you, but nonetheless, it was an interesting case, I think.
Very interesting case, and to me, at least from my standpoint, showed the proposition that my reasoning was not outcome determinative. This was, I think, the only Second Amendment case that I had in the 22 years that I was on the bench. And, we looked up the law and heard the arguments, and then made a decision based upon what we thought the correct interpretation of the law was. And if the law was that Mr. Woolard couldn't get the handgun permit, then he couldn't get it. And so that's what I meant by going on to the next case.
Absolutely. Well, in that vein, going on to the next couple cases, the last ones we want to discuss are two death penalty cases, or at least cases that involved the death penalty. The first is Evans v. Sarr.
Why don't we do Mr. Thanos first?
Well, then we'll start with Mr.
First
Thanos.
one,
then.
chronologically.
Right, chronologically, Mr. Thanos was a criminal case, a death penalty challenge, and the unique part of that case was who was making the challenge, and why don't you tell us about the issue of who was speaking on behalf of Mr. Thanos?
John Thanos, who's about Herb's and my age. If he were still alive, if he hadn't been executed, he'd be around 68 to 70. And he was a tragically flawed individual, hard upbringing, in jail most of his adult life, and a sociopath. And I'm reading from part of the Baltimore Sun. His crimes were brutal. He executed 3 teenagers with a sawed-off .22 caliber semi-automatic rifle, which he carried around Maryland in a leather doctor's bag. He calmly confessed to his crimes while smoking a cigarette and while complaining that the police failed to kill him, because his objective was to kill people and then have the police kill him. I just wanted the basics to keep me alive so I could kill until they could kill me, Thanos said in his videotaped confessions, and goddamn, I'm still alive and in pain. At one point, he lectured the Garrett County jury on religion. Later, when facing a death sentence, he went to extremes to demonstrate his lack of remorse, claiming he would like to bring his victims back to kill them again. So Thanos was Mr. Thanos was sentenced to be executed, and he fired his attorneys and declined to take an appeal. The Maryland courts upheld his declination to take an appeal, so he filed, not he, but his relatives, his mother, and then anti-death penalty groups such as the ACLU filed a lawsuit in federal court contending that Thanos must be insane if he wished to forego his appeals to be executed. And they wished me to require Thanos to take an appeal to the Maryland appellate courts to contest his death sentence, and they wanted me to require the Maryland courts to hear those appeals.
And during this, you had the case and you had a hearing, and you had the opportunity or made the decision to call Mr. Thanos to the stand yourself to question him to determine whether or not he was had competence to represent himself and work appropriately with his lawyers. So why don't you tell us about your decision to call him to the stand and how that played out?
Well, as one might imagine, there are a host of standing issues. There are also a host of competency issues, and Mr. Thanos had been examined by the state authorities and had been determined to be competent to assist his counsel. So one of the arguments that was made was that Thanos must be incompetent because he refused to accept his attorney's advice. And the ruling in the state court was that he was sufficiently competent to assist his attorneys in his own defense, and that he wasn't incompetent simply because he rejected their advice. So I personally wanted to hear what Mr. Thanos had to say, because on the one hand, I thought that I could see the merit in the argument that most people treasure life and would take every opportunity to prolong their life, their own life. So I thought I'd like to hear from Mr. Thanos, and Mr. Thanos objected vehemently to having attorneys sitting at defense at, I guess it would have been the plaintiff's table, trying to urge positions on his behalf. So I said, Mr. Thanos, if you don't mind, please take the witness chair so that everybody can see you and we can hear you. And I asked him why he did not wish to take the appeals. And as you can see from some of the news accounts, he was not an ignorant man, and he liked to write, and he liked to write poetry, so that he was an extremely flawed individual, but he was perfectly lucid and cogent in his explanation. He told me, he said, I'm not particularly, I don't really want to die, but I realize that I will never, ever be released from prison. I have spent most of my adult life, I'm paraphrasing here, in prison, and the state of Maryland will never let me go. And I would rather have my life ended than spend the next 40 years in prison. So, if I'm executed, it's over. And I thought that sounded, it might not be the decision that I would make, that many would make, but it's certainly a lucidly expressed and logical decision about his own life. And so basically I thought that he makes sense to me, and that he should be in control over his own destiny, whether he's going to be executed or not. Now, Vernon Evans, of course, made the different decision that he did not want to be executed.
So that's the next case, Your Honor, that I wanted to move to, and that's the case of Vernon Evans v. Sarr. And that involved an individual, Vernon Evans, who was on death row.
This is the last one, Herb. I realize we've been here for a while.
We'll go through this quickly. But again, to set the stage on that, that was a suit brought to challenge the Maryland State lethal injection protocol. And that protocol, which was adopted as a more humane way of conducting an execution, involved a 3-drug cocktail that was injected into the defendant. The first was an agent, I'm not going to attempt to use the scientific names, but one effectively that would numb the defendant so he wouldn't feel any pain, or she. The second was, and that was to avoid agony, and then the second 2 were designed to both independently have the capability of executing, killing the defendant. The first was a muscle paralyzing agent, and the third was an agent that stopped the heart. So tell us, what was the issue, what was the problem that Mr. Evans and his lawyers had with that death penalty protocol?
Well, just a little bit of background about Vernon Lee Evans. Mr. Evans was a defendant in a celebrated case that involved Evans, who at that time was a drug addict, and Anthony Grandison, who was a drug kingpin. And Grandison, who was about to stand trial on federal drug charges, hired Evans to kill 2 witnesses who were expected to testify against in the Grandison trial against Grandison, Susan Kennedy and David Scott Pekowitz. And tragically, Susan Kennedy wasn't the individual who was going to testify. It was her sister who was standing in for her behind the counter at a motel, and just happened to be there. And when Mr. Evans came in and shot both Mr. Pekowitz and Ms. Kennedy. So that all happened well before I joined the bench. Mr. Evans was convicted, sentenced to death. When you're sentenced to death, you're not executed anytime soon. His case then proceeded along to direct appeal up to Maryland Court of Special Appeals and the Maryland Court of Appeals. And then after that, it goes through a state habeas corpus. And then when that's exhausted, it comes over to federal court for federal habeas corpus. So one of my early cases was a federal habeas corpus case filed on behalf of Vernon Lee Evans by very astute, large, sophisticated Washington law firms who raised every conceivable issue that could be raised, including the argument that you have original lawyers replaced by new lawyers, a set of lawyers, and then another set of lawyers. Third set of lawyers contends that everything that set number 1 and 2 did was incompetent, and lawyers number 1 and 2 all file affidavits saying, absolutely right, we were incompetent, we should have, done X, Y, and Z. It took me an inordinate amount of time to puzzle and work my way through what were probably 50, 75, 100 different issues. I had ended up writing a 95-page opinion denying the federal habeas corpus, the petition. So then the case then disappeared for a long period of time, where it went up to the Fourth Circuit when I was affirmed, and then up to the petition for certiorari, the Supreme Court. Cert's turned down. The next thing I know, I have Mr. Evans again, because Mr. Evans, assisted by very fine attorneys, including Kalea Clark Seitz, one of my former clerks, had filed a lawsuit contending that Maryland's lethal injection protocol constituted cruel and unusual punishment. And the argument had 2 pieces to it. The first is that many people who are on death row have compromised veins, both in their arms and their legs, through a history of intravenous drug abuse. And second, that this cocktail, which originated and was thought up in Oklahoma, carries a risk of misfiring because the first piece of the drug is supposed to render you incapable of movement, and then the second and third drugs are supposed to kill you. Both drugs 2 and 3 can cause excruciating pain. So the argument is that a person might be paralyzed but not knocked out, not unconscious, and capable of feeling this great pain, but incapable of letting anybody know about it. The apparatus for injecting the lethal injection sort of looked like the Rube Goldberg machine, with tubes going every which way, for 2 reasons. One is that in an execution, the executioner's identity is masked. So that the person, we can see Mr. Evans if he was going to be injected, but we couldn't see the person who's actually doing the injection, which means that he has to be several feet away. I was told that doctors would not perform a lethal injection because it was in violation of the Hippocratic Oath. And therefore, the people who were lined up and would do them were paraprofessionals, like EMT professionals. So Mr. Evans's very fine attorney said that Rube Goldberg machine compromised, or apparatus compromised veins, and not having a doctor means that there's too much of an opportunity for misfiring. So what I did is, this was sort of at the tail end of Maryland even trying to execute anybody perfectly. So what I did is I told the state, at one of the hearings, I said, have you ever tried to find a doctor to perform a lethal injection? Because it would certainly be preferable from a not misfiring standpoint. And they said, no, we haven't. So I said, well, here's what I'm going to do. I'm going to stay the case. And I'm going to order you to try to find, and you're going to have to do a diligent search, a doctor who will do this. Particularly one who will have no qualms about having his or her face shown so that that doctor can be close to the injection site. And the case then sort of disappeared from my docket during the stay and was overtaken by Governor O'Malley's ending of the lethal injection in Maryland, and he didn't parole Mr. Evans, but he took them. He's still on death row, I believe.
Yeah, I believe it was the Governor O'Malley put a moratorium on
right.
the death penalty, and Mr. Evans remains on.
Right.
At least
I thought his death sentence was commuted, but in terms of my involvement, so I think he's still in serving a life sentence, but I think it was commuted.
Well, thank you, Your Honor. With that, I'm going to turn it over for one last segment, once again, to PJ.
Thanks, Evan. Judge, we've spent some time now covering specific cases in some detail, and I wanted to back up and ask you generally about some of your recollections of your career. First, I'd like to ask you about trial practice in this district. In your 22 years on the bench, how, if at all, did you see trial practice change in this courthouse?
Good. Quickly, and don't let me forget to mention law clerks and courtroom personnel. And I did forget to say that Paolo Morante, who's now at DLA Piper in New York, helped me write the Merck Medco opinion, and I'm very grateful to his expert efforts. A number of things have happened in the practice of law in my career. The first is that if you're a young lawyer, it's very difficult to get into trial. We calculated that less than 1% of all civil filings in the federal system ever go to trial. And often it's because it's an oddball case or an oddball attorney. They all settle. And this is, in my view, just a very unfortunate circumstance because the trial system has become a settlement system. And if you don't, and the judiciary sets up a number of roadblocks to prevent you from going to trial because there are just not enough lawyers in courtrooms. So you have to be persistent actually to get to trial, and they're going to try to make you settle the case. The second is that with respect to the caseload, when I was a young lawyer and a young judge, most of the cases that we had were Company A suing Company B, a great many commercial cases, business cases. And as Maryland's economy has been hollowed out with the loss of Bethlehem Steel and the Broning Highway GM plant and all of the manufacturing plants, the caseload has morphed from Company A suing Company B to a lot of other cases, including primarily workplace cases, FLSA, Title VII, and the other anti-discrimination cases. Those latter cases are very important cases because Herb and I grew up in a world that was segregated, where minorities had few employment opportunities and women did not have employment opportunities. So those cases are very important cases. They're often difficult cases because there are so many procedural hurdles that you have to, like exhaustion, that you have to jump over before you ever get to the what happened. But I do miss many of the commercial cases that used to be filed. And with respect to the number of trials, I was finding at the end of my tenure on the bench that it was hard to get into court. You know, think so many of the civil cases settled, and on the criminal side of the docket, about 95, 96, 90%, 97% of all the criminal cases are resolved by a plea. So one of the reasons I wanted to be on the court was to be in trial, and I found that at the end of my tenure, it was hard to get into trial.
Judge, you also mentioned some of the role models you had both during your career as a practicing lawyer and during your early years on the bench. And I know for Evan and I, you were a role model in our own careers. And for any of the young lawyers watching this, I was hoping you could share some of your wisdom on what young lawyers who practice before this court can do to enjoy the success that you've had in your career.
I think that, last night I was down in Georgetown, your alma mater, helping teach a criminal practice course that one of my friends gives every year. And one of my, what I think is very important for young lawyers is to pick the right role model. And if you're litigating motions practice, discovery, or interactions with the court, you have to be honest, cooperative, and the honest guy. That doesn't mean that you have to give up your position, but you have to be measured and professional. I found, and we discussed this when you were clerking for me, that there were three types of attorneys. A group of really good attorneys, you know, like your father, like Herb, who will be honest with you. You know, counsel, I don't know much about the Lanham Act. Please explain it to me and your claim. And that good counsel will be able to describe the cases and will say, yeah, there are 5 elements to the Lanham Act claim, and we're representing the defendant. number 1 and 2, they definitely satisfies. They're not going to be at issue, but we're going to be litigating 3, 4, and 5. Because the judge will pay attention to you and treat everything that you say seriously. Then lawyers in the second group aren't quite so good, and they're not reliable, so the judge tends to discount or ignore what they have to say. And then there's a third group that will actively seek to mislead you, and they have no influence with the judge. So pick a good mentor, somebody who fits your personality, that you think is first class. Observe them and emulate them.
Well, that's excellent advice, Judge. I'm glad we now have it in the vault of the court's oral history. You also, throughout this interview, have talked about law clerks and staff members, and I wanted to give you an opportunity to share with the audience, for those who haven't had the privilege of working in a judge's chambers, how a judge's chambers is run and what goes into running the judicial machinery at the district court level.
Well, it's a marvelous world that we inhabit, because when you think of the judiciary is one part of what we used to call, or we still do call, the court family, which includes the clerk's office, chamber staff, and then the institutional litigators, the public defender's office, the U.S. Attorney's office, and then the lawyers who were on the Criminal Justice Act panel. In chambers, it's just a very entertaining, wonderful environment. We'd have a judicial assistant. It's hard for me not to call the judicial assistant a secretary, so I'm just going to call them the secretary. And I had 3 wonderful principal secretaries. When I came on the bench in 1991, Judge Kaufman gave me a call and said, I'm getting older. Betty Wiegand, and Betty was clerk for Judge Kaufman when I was a clerk from 1974 to 1975. Would you take Betty? So I said I'd be delighted to take her. So she came to work with me for about 10 years at the start of my career. I talked to Betty yesterday, and she said that one of the things she remembered is how much fun we used to have. That in the morning I would come in and I'd sit by her desk, and we'd bring the law clerks in, and we'd all discuss the sort of events of the day or cases. And Betty remembers just how much laughter there was. We took things seriously, we worked hard, but we had a lot of fun. Those discussions, by the time you came on, pretty much centered on the Baltimore Orioles and their travails, but it's particularly when you get older, it's hard not to be ghettoized into your own age group. I now spend large parts of 3 months a year down in Florida, a place called Johns Island, and everybody's pretty much the same. Affluent people who are between the ages of about 60 and 85, large preponderance of conservative Republicans, and you don't get the perspective of the young. And having law clerks means that you find out what the young are thinking, what they are feeling, what their careers are like, how they change. And it was just a marvelous thing to have. I'd keep getting older, but they would never get older because they were all pretty much the same age. Then Betty retired and came to work for Kyle and me at our house for about 10 years, helping with bookkeeping and other issues because my wife was working full time. And then she was replaced, after Betty retired, Ann Cahill came to work for me for about 10 years and was just marvelous. And then she retired to Haverty Grace, and then Debbie Fales came to work. She had been for about 7 years the assistant secretary, and I snapped her up to be the principal secretary. And she's just so efficient and a delight to work with. And then I had 2 part-time secretaries, Kathy Mulqueen and Beth Thomas, both wonderful people. Unfortunately, Beth is no longer with us. She died of cancer just this past year. And complement of marvelous deputy courtroom clerks who are all favorites of yours. Pete Thompson, you can always talk about the Baltimore Colts. Love Pete, great sense of humor. Karen Moyer, great sense of humor, and you didn't want to cross Karen. She was, you know. And then Martina West, who I didn't understand is now married, but I can't, you were telling me that I've got to give her a call and wish her congratulations. And just wonderful. And then very fine court reporters. I have so much respect for court reporters because their job is mentally taxing, because unlike me, I can sort of, fade out a little bit if I'm not engaged by the argument, but they have to pay attention constantly, and their fingers and wrists are always moving. So I remember Ned Thompson, remember Ned? And Gail Simpkins. My two principal court reporters over the years, and I was blessed, were Jackie Sovich, and just marvelous person, funny, witty, hardworking, diligent, just a pleasure to have in court. And she's had some physical problems, and I wish her the best. And then Mary Zajac, who was also great and hardworking and just a terrific sense of humor. So I was blessed in that respect. Great law clerks, great court reporters, great courtroom deputies, great secretarial staff, just a marvelous working environment. And you're in charge, so you don't have to put up with a lot of back chat.
Well, Judge, you mentioned a large village of people that make this courthouse work and make it such a pleasant place to practice. And on behalf of all those people...
I forgot to mention the clerk's office, because then the personnel in the clerk's office are very fine and keep things humming along. And we've had blessed with some really good chief clerks. When I started, when I was with Judge Kaufman, Paul Schlitz was the chief clerk. And at the end of my career, I was blessed to have Felicia Cannon be the clerk. Felicia cannot be overpraised. She's on top of absolutely everything. She's so efficient and smart and easy to work with. When I signed off after my tenure as chief judge, I said that the secret of my success was just to turn things over to Felicia, let her run things, and that it worked for me for 7 years.
Well, Judge, on behalf of Evan and I, your former clerks, your staff, and the Maryland Federal Bar, I want to congratulate you on a distinguished career, and I want to thank you for your many years of service to the U.S. District Court for the District of Maryland. You are remembered in this courthouse as a wise legal thinker, a wonderful mentor and colleague, and a consummate gentleman on the bench. So again, on behalf of all of us in the courthouse community, congratulations and thank you.
You're very welcome. It was my pleasure.